Here's a number: $1,224,000,000. That is the combined total that Google has paid in settlements, fines, and legal judgments, specifically related to one thing: collecting, storing, and using your location data without your knowledge or meaningful consent. Not alleged, not disputed, settled in court, with judges approving the terms and attorneys general from 40-plus states signing their names to the accusations. Courts in California, Arizona, Texas, Indiana, Washington State, the District of Columbia, and the federal system have all processed versions of the same basic allegation. Google told you it would stop tracking your location when you turned off location tracking, and then it tracked your location anyway. It built behavioral profiles from those movements. It used those profiles to sell targeted advertising, and it did this to hundreds of millions of people across a decade, while the setting that was supposed to stop it sat in your phone looking like it was working. This is not a hidden setting in the sense that it is hard to find. It is hidden in the sense that what it actually does, and more specifically what it fails to do, was deliberately obscured from the people who were supposed to be controlling it. Today, we are going to go through the full documented story of what Google did, what the courts found, what the settlements required, and exactly which settings on your phone and in your Google account you need to change right now to actually stop what the turned off setting was supposed to stop but didn't. Let's go. Let's start with the core finding that underpins every settlement, every lawsuit, and every Attorney General investigation in this story, because it is specific enough that it cannot be dismissed as vague corporate malfeasance. Plaintiffs allege that Google collected and stored their location information without their consent while location history was disabled. Read that precisely. Location, history. The specific setting in your Google account labeled location history, the one that, when turned off, is supposed to stop Google from recording a timeline of your movements, was disabled. Users had found it, understood what it claimed to do, turned it off, and believed they had opted out of location tracking. And Google was collecting their location data anyway. How? Through a second system that operated entirely independently of the location history toggle. Google's apps, Google Maps, Google Search, the Google app itself, and other Google services were logging location data as part of what Google called web and app activity. This is a separate setting with a separate toggle in a separate section of your Google account settings that most users had never found, never read the description of, and never connected to the question of whether their location was being tracked. The location history toggle controlled one data stream. The web and app activity setting controlled another. Turning off location history left web and app activity running. And web and app activity logged your location every time you used a Google app or service, which, for most Android users, is dozens of times per day. Google was telling its users one thing, that it would no longer track their location once they opted out, but doing the opposite and continuing to track its users' movements for its own commercial gain. That is the California Attorney General's characterization, stated publicly in the announcement of a $93 million settlement. Google generates the majority of its revenue from advertising, and location-based advertising is a critical feature of Google's advertising platform because advertisers want the ability to market to users based on their geographical locations. Google also uses location data to build behavioral profiles of users to help determine which ads to serve users. The motivation was not mysterious. Location data is among the most commercially valuable categories of personal information because it enables advertising targeting at a specificity that behavioral or demographic data alone cannot match. An advertiser who wants to reach people who visited a competitor's store, people who commute through a specific neighborhood, people who attend a specific type of venue, or people whose daily routine places them in a particular economic category. All of these targeting use cases depend on location data, and Google, whose advertising revenue funds the overwhelming majority of its business, had powerful financial incentives to maintain location data collection regardless of what the user-facing settings implied. Let's go through the full settlement record, because the scale of the legal accountability Google has faced for this specific practice is something most users are completely unaware of. And understanding it is what gives the rest of this conversation its full weight. In 2022, a coalition of 40 attorneys general across the United States reached a $391.5 million settlement with Google over location tracking practices. This was described at the time as a record privacy settlement in the United States. The investigation found that Google had continued collecting location data from users who had disabled location history through the web and app activity mechanism. Google paid. The attorneys general signed. The settlement required Google to make changes to its disclosures and settings. Also in 2022, Arizona reached a separate $85 million settlement with Google over the same category of allegations that Google used location data without consumer permission for targeted advertising. In 2023, the California Attorney General filed a separate action and reached a $93 million settlement with additional injunctive requirements compelling Google to change specific practices around how it disclosed and managed location data collection. In July 2025, a class action covering approximately 14 million California Android users settled for $314.6 million, specifically related to allegations that Google surveilled and collected cellular data for targeted advertising. On January 27, 2026, Google submitted a proposed $135 million settlement covering all individuals in the United States who used Android devices to access the internet on cellular data networks between November 12, 2017, and the date of final approval. The settlement received preliminary court approval on March 5, 2026. This settlement covers more than 100 million Americans. On March 26, 2026, a district court approved a historic settlement protecting the privacy rights of hundreds of millions of Google account holders across the United States. The lawsuit alleged that Google sells personal information, including browsing history and real-time bidding auctions, for targeted ads billions of times every day. Despite Google's express promise that Google does not sell your personal information to anyone, real-time bidding is the automated advertising auction system through which, in milliseconds, your behavioral profile, assembled from your location history, your search history, your browsing history, and your app activity, is transmitted to hundreds of advertising companies simultaneously, so they can bid for the right to show you a specific advertisement. Every time a web page with advertising loads in your browser, this auction is happening. Your data is being transmitted to bidders you have never heard of, and the profile being bid on was built in part from location data you believed you had disabled. Google reportedly stored location data for users who had explicitly turned off location history on their devices. That's the core of why this case exists. The total settlement value across these cases, combined with the 40-state $391.5 million settlement, the Arizona $85 million settlement, the California $93 million settlement, and the subsequent 2025 and 2026 settlements, brings the documented legal accountability for Google's location data practices to well over $1 billion. And every dollar of that came from courts and attorneys general finding that what Google was doing was not consistent with what Google was telling users it was doing. Now, let's talk about what is actually happening on your phone right now, because the settlements required Google to make changes to its practices and disclosures. But those changes do not automatically fix the settings on your device. The required disclosures are clearer than they were. The settings have been made somewhat more findable than they were. But the default configuration of a Google account on a new Android device still involves multiple active location data collection systems, and understanding each of them is necessary for making informed decisions about which ones you want running. The first system is location history, now renamed in Google's interface to timeline. This is the system that creates a visual timeline of your movements, the feature that, if you have ever opened Google Maps and seen a record of places you visited, you have seen in action. When enabled, this feature stores a detailed chronological record of your movements that is tied to your Google account. It is stored on Google's servers unless you have configured it to store locally only, and it is used, according to Google's privacy documentation, to provide personalized recommendations, improve Google services, and inform advertising. The setting to control this is in your Google account settings under Data and Privacy, then Location History or Timeline. The second system is Web and App Activity, the one at the center of the lawsuits. This setting controls whether Google logs your activity across Google's apps and services, including the location data that those interactions generate. When you open Google Maps and search for a location, that search and your device's location at the time of the search are logged under Web and App Activity, even if location history is turned off. When you search on Google for a local business, that search and the location context are logged. When you use any Google service that accesses your location, that access is recorded under Web and App Activity independently of the location history setting. This is the gap that the lawsuits documented and that the settlements addressed. The setting is in your Google account under Data and Privacy, then Web and App Activity. The third system is your device-level location permission, the setting that controls whether your Android phone's GPS and network-based location hardware can be accessed by apps at all. This is separate from both Google account settings described above. Device-level location permission operates at the Android operating system level and affects all apps on your phone, not just Google's. Controlling which apps have location access and at what level, precise GPS location versus approximate network-based location, is managed through settings, then location, then app permissions on your Android device. The fourth system is Google's advertising ID, the identifier assigned to your Android device that is used to link your activity across different apps for advertising purposes. Even when location-based targeting is limited, the advertising ID provides a persistent identifier, that allows advertising networks to build a profile of your app usage and browsing behavior over time. Managing or resetting this identifier periodically reduces the continuity of the behavioral profile that advertising networks maintain for your device. Now let's go through exactly what to do, step by step, setting by setting, to actually address each of these systems rather than assuming that any single toggle has handled all of them. The first step is accessing your Google account's data and privacy settings. On your Android phone, open the Google app or go to My Account, Google. Com in a browser and navigate to Data and Privacy. This section is the central control panel for Google's data collection settings and the place where most of the relevant changes need to be made. The second step is addressing location history, now called Timeline. Within Data and Privacy, find Location History or Timeline and open its settings. You will see the option to turn it off entirely, which stops Google from recording your future movements in the Timeline feature. You will also see the option to delete existing timeline data, all of it, or within a specific date range. If you have never reviewed this setting and have had location history enabled on your Google account, the timeline data Google holds about your movements may span years and contain a detailed record of places you have lived, worked, traveled, worshipped, sought medical care, and visited for any other purpose. Deleting this data removes it from Google's servers. Doing both, turning off future collection and deleting existing data, is the most complete intervention for this specific system. The third and most important step is addressing web and app activity, because this is the setting at the center of the documented court-settled deceptive practices. Within Data and Privacy, find web and app activity. Open it. You will see a toggle to pause this activity. Pausing web and app activity stops Google from logging your future activity, including location context, across its apps and services. Like location history, you also have the option to delete existing web and app activity data, which removes the historical record of searches, app usage, and associated location data that has accumulated under this setting. For users who want to retain some Google Services functionality while reducing location exposure specifically, there is an additional option within web and app activity to uncheck the specific inclusion of location data in activity records. Look for a checkbox or subsetting related to including location in activity and uncheck it if present in your Google account version. The fourth step is reviewing device-level location permissions for individual apps. Go to Settings on your Android device, then Location, then App Permissions. Review every app that has location access. For any app showing all the time access, evaluate whether that level of access is actually necessary for the function you use that app for. Change 2. While using the app for any app where continuous background location access is not a core requirement, deny location entirely for apps where you cannot identify a legitimate need for it. Pay specific attention to Google's own apps in this list: Google Maps, Google, Chrome, Google Photos, and any other Google applications, and evaluate whether the access level granted is what you actually want these apps to have, given what you now know about how that location data is used. The fifth step is managing your Google Advertising ID. Go to Settings on your Android device, then Google, then Ads. Within the Ads settings, you will find the option to reset your advertising ID, which assigns a new random identifier to your device, breaking the continuity of the behavioral profile that advertising networks have built against your old ID. And in Android 12 and above, the option to delete your advertising ID entirely, which prevents apps from accessing a persistent advertising identifier at all. Deleting rather than resetting is the more complete intervention if you want to prevent ongoing behavioral profiling through this identifier. The sixth step is reviewing Google's My Ad Center, which is a relatively recently introduced interface at My Ad Center, Google. That gives you visibility into the interest categories and demographic inferences that Google has assembled from your data and that are used to target advertising toward you. While reviewing this does not stop the underlying data collection, it gives you concrete visibility into what Google's advertising profile for you actually looks like, and the ability to remove specific interest categories from your profile, which modifies the targeting that applies to you in Google's advertising systems. The seventh step specifically addresses the real-time bidding data transmission issue documented in the March 2026 settlement. The settlement required Google to make changes to how profile data is transmitted through the real-time bidding advertising auction system. However, the most effective personal protection against this mechanism is using a browser with third-party cookie blocking and ad tracking protection. Firefox with enhanced tracking protection enabled, or Brave, rather than Chrome, which, as we discussed in our earlier browser episode, has structural incentives for more permissive advertising tracking by virtue of being built by a company whose primary revenue depends on that advertising ecosystem. On mobile specifically, using Firefox Focus or Brave for general browsing rather than Chrome reduces the data contributed to the real-time bidding profile that is bid on every time a web page with advertising loads. The eighth step is checking whether you are eligible to participate in any of the pending Google settlements, since several of the settlements covering location data practices have claim processes through which affected users can receive compensation. If you used Google services while the company allegedly tracked your location without proper consent, you may be entitled to a payment in 2026. Settlement payment timelines in class actions are rarely precise, but payments could begin in the second or third quarter of 2026. The settlement websites for these cases searchable through class action. Org have claim filing processes with specific eligibility windows. Whether you qualify and how much any payment might be depends on the specific settlement's class definition and claim volume. But given that the settlements cover essentially all Android users in the United States over extended periods, a large number of people reading this are likely within the covered class for at least one of these settlements. Let's step back now and address the question that the settlement record raises most directly. If Google paid over $1 billion in legal accountability for these practices, are those practices still happening today? The honest answer is nuanced. The settlements imposed injunctive requirements on Google, meaning Google was required to change specific practices and disclosures as part of the settlement terms, not just pay money. The disclosures around location history and web and app activity are more prominent and clearer than they were before the lawsuits. The settings for managing these features are more findable than they were. Google has made its auto-delete options, which automatically delete your activity data after 3 months, 18 months, or 36 months, more visible and easier to configure. But the fundamental architecture has not changed. Google still collects location data through multiple systems simultaneously. Those systems still operate independently, such that disabling one does not disable the others. The data collected is still used for behavioral profiling and advertising targeting. And the default configuration of a new Google account on a new Android device still has web and app activity enabled, meaning that a user who buys a new phone today, who has never heard of these settlements, who has never found the data and privacy settings, is in the same position that the plaintiffs in these lawsuits were in during the period the case is covered. The settlements changed what Google tells you. They did not fundamentally change what Google does by default. The default is still collection. The burden is still on you to find the settings, understand what each one actually controls, and actively configure your account in a way that reflects your actual preferences, rather than the preferences of a company whose revenue depends on the data those defaults generate. That is the structural reality that $1 billion in legal accountability has not altered. And it is the reality that every Android user navigates every day, most of them without knowing the settlement history, the two-setting gap that the lawsuits documented, or the specific steps required to actually address each collection system rather than only the most visible one. Now you know all of it: the legal record, the specific mechanism, the specific settings, the specific steps, the specific eligibility for claims from settlements funded by the legal accountability that courts have imposed on these practices. What you do with that knowledge is your decision. But it is now an informed decision made with full visibility into what has been happening in court-documented form for the past decade on the device in your pocket. Your location is your own. 8 steps stand between where you are right now and having it treated that way.